this is the second time that basically we've had Dr. Natasha BAKHT sort of attempt to come to the center. I'm so glad that last time we sort of misorganized or got the dates wrong, and then we had a conflict with the holiday and she couldn't speak, and I'm really, really pleased that you might. Natasha BAKHT is basically an associate professor at the University of Ottawa's Faculty of Law, and she works in the areas of law, culture and minority rights, and her most recent writings on the rights of niqab-wearing women were actually cited by the Supreme Court in Canada. She's also has an edited collection called Belonging and Banishment, Being Muslim in Canada. And she is currently also the English language editor of the Canadian Journal of Women and Law. Today she's going to speak to us on the topic of In Your Face, Piercing the Veil of Ignorance about Niqab-Wearing Women. And I am extremely pleased that she's going to be talking about this for various reasons. And I welcome you again. I guess you can speak. What were you planning, about 40-45 minutes?
Yes.
Yeah, and then we can have some questions after. Yeah.
Well, good afternoon, everyone. Can you hear me? I'm thrilled and a little shocked to see this many people here on a sunny Friday afternoon, so thank you very much. The Western world seems to be at an astonishing historical moment when, in the 21st century, women's clothes are the subject of legislation, judicial consideration, and much public acclamation. We seem to have barely dealt with the fact that some women cover their heads, that the latest focus, certainly in Canada but elsewhere as well, the latest focus of anti-Muslim hysteria is in full swing, and this time it's over women who cover their faces using a niqab. There are a variety of reasons that are offered in support of the belief that women should not be permitted to wear the niqab. Sort of coming in and out. Can you still hear me?
Maybe it's easier if you just...
what do I need to do?
Maybe we should back a bit.
Push the mic back?
Maybe, I don't know.
How's that? Can't hear me now?
No.
Okay. How's this?
Yeah.
Yeah? I'll just stay in this position. Okay.
Do you know what happened to the other mic? If you could do that, that would be, sorry, things are in a bit of a disarray today.
No worries.
If you can get that work, can you get that working?
Yeah, just try.
Yeah, something big, because
I just for
I think we can continue.
no, that's an interruption, which is too long. I wonder what happened to Swasti.
Put your hand up if you can't hear me.
You should put that off.
Push it away from you.
Yeah?
Yeah.
Okay. So there are a variety of reasons that are offered in support of the belief that women should not be permitted to wear the niqab in certain venues. And some of these include that the niqab oppresses women, that it prevents integration, it offends secularism and tolerance, it decreases security and communication. Some have argued that it is impolite, it encourages proselytism, and that it is simply not a religious requirement. Well, I would argue that the niqab cannot be understood as a symbol with singular meaning.
a report that was produced by the Canadian Council of Muslim Women, which is one of the main Muslim women's organizations in Canada, interviewed several niqab-wearing women in Ontario and found that the reasons they provided for wearing the niqab were highly personal and highly diverse. So contrary to the prevailing view that male family members force niqab-wearing women into this particular attire, the study suggested that many niqab-wearing women in fact faced familial opposition to their very personal decision to wear the niqab. So the report really, at least in Ontario, and there's another report coming out of France which echoes these findings, sort of puts into question the contention that we must rescue niqab-wearing women from oppression. In fact, the decision to wear the niqab, or indeed any clothing, is likely a strategic choice made in always already constrained relational environments whose costs and benefits vary depending on the circumstances. So instead of being a symbol of a unilateral instrument of submission or even free expression, the preference to wear the niqab is shaped likely by multiple interactions and regulation. My research to date has shown that niqab-wearing women are in fact not the submissive women that much of society believes them to be. They are in fact advocating as advocates in courts of law, they're teaching in schools, they're pursuing higher education, they're litigating their rights in courtrooms, and they're interacting with male cabinet ministers, for example, about issues of concern to them. The niqab is a critical component of who they are. So to deny them access to fundamental legal institutions on the basis of their identity is, I would argue, to deny their dignity. Nonetheless, I hear on a regular basis, especially in Canada and the United States, how uncomfortable the niqab makes people feel. And I sort of suggest to these people, sometimes to no avail, that comfort is not an effective measure for interactions in a diverse society. But I've tried to sort of consider, what is it that makes people so uncomfortable? At one level, I think it's simply fear of the unknown, fear of that on which we have inscribed ideas of radicalism, terrorism. But fear, like discomfort, is not a very good advisor. Dr. Catherine Bullock has suggested that our discomfort is about the interruption of the gaze. That with niqab-wearing women, she sees us, but we don't see her. Sure. So, how's this working?
I think it's no, just shut it off. We can hear you perfectly without anything. It's making so much noise.
Better? So much better. Okay.
Thanks.
So, Dr. Catherine Bullock, I was saying, has suggested that our discomfort is about the interruption of the gaze. So the niqab-wearing woman sees us, but we don't see her. So she subverts the typical power relations in that she sees, but she's not seen. Well, whatever the reason for our dislike of the niqab, and there may be other reasons, I would argue that to live peacefully in a diverse democracy, we need to develop empathy that enables us to see the world from the point of view of others. Excuse me. Just getting used to the deli air, so developed a cough. Okay, so today what I'm going to do is concentrate my remarks on niqab-wearing women in the courtroom context. So I've done some research about niqab-wearing women in other contexts as well, and I'm happy to talk about that in the question-and-answer period. But I'll concentrate my remarks about to niqab-wearing women in the courtroom context. And what I'll do is I'll examine 3 judicial decisions in 3 different jurisdictions. Canada, I'll start with Canada, move on to New Zealand, and then England. And I'm going to start with Canada in part because it's where I'm from, but also it's the only case where the highest court of that particular land has actually rendered a decision with respect to niqab-wearing women, and it's been quite influential in other cases. So in a case called R and NS, the Supreme Court of Canada examined whether a devout Muslim woman sexual assault complainant could wear her niqab while testifying in court. So NS is a Muslim woman from Toronto. She had worn the niqab for about 8 years, we're probably going on 12 years now, and she alleged that 2 male relatives of hers had sexually assaulted her over a period of years. So this was a historical sexual assault case. The lawyers for the accused objected to NS wearing her niqab. They argued that in order to effectively cross-examine her, they needed to be able to see her face to gauge her reactions to their questions. And they also argued that the trier of fact, in this case it was the judge, would have difficulties making credibility assessments unless they were able to see her face. So as you may know, judges and juries are permitted generally in law to assess the credibility of witnesses and the accused based on demeanor evidence. And so what that means is that they're permitted to evaluate the trustworthiness of a person in court based on their appearance, their attitude, and or their disposition. Now there's much case law that exists in Canada and in other countries to support that contention. But there's also a growing body of case law and social science literature that warns judges about the excessive use of demeanor evidence because of its inherent unreliability. So it's very common for individuals to believe that they can determine when they are being lied to. Professor Paul Ekman, in his study of lying, found that with rare exception, no one can do better than chance at spotting liars simply by their demeanor. We know that in racial profiling cases, perfectly innocuous behavior is often interpreted as suspicious simply because the observation was occurring through a stereotypical lens. I can tell you that I've been through law school, and we don't learn in law school whether or not somebody is lying and what the indicia are of people, whether they're telling the truth or not. It's just not simply something that one learns. So judges don't have that ability either, much as they think they might. In the sexual assault context, the concern is that demeanor evidence will result in reliance on inappropriate myths about the way women ought to react to sexual assault, penalizing those who do not fit into such rigid characterizations. Clearly, it's women's words that matter, not women's bodies or how we look or what we're wearing. So the majority decision by the Supreme Court of Canada did not prohibit niqab-wearing women from courtrooms outright. Indeed, Chief Justice McLaughlin confirmed that Canadian law does not require that people park their religion at the courtroom door. That's, and I quote. What the majority decision does is it provides trial courts with an analytical framework to structure their reasoning. But in my view, it's a framework that skews the balance in favor of the ban of the niqab more often than not. So what the court has said is that when evidence is uncontested, a woman can wear her niqab. But in a sexual assault case, the evidence will necessarily be contested. So he's going to say, I didn't rape her, and she's going to say, yes, he did. The majority's concern was the accused's right to a fair trial, which is of course important. But interestingly, the majority failed to consider their own guidance from a previous case called R and Mills, in which what they said was what constitutes a fair trial is consideration not just of the rights of the accused, but also the public interest in prosecutions that are sensitive to the needs of victims and witnesses. So my worry is that the effect of the judgment will be that niqab-wearing Muslim women will be less likely to report their sexual assaults. And we already know that sexual assault is a very underreported crime. And that this is going to renew rape myths about the way sexual assault complainants ought to appear. I think the decision also further marginalizes an already stigmatized group and tells them that justice will not be done for them. The fact that the case is a sexual assault case, so that sexual assault context, also I feel deserves heightened sensitivity, given the history of legal and procedural norms and rape mythologies that re-victimize complainants and reinforce their inequality. The fact that a complainant, a sexual assault complainant, would be required to strip, essentially, she's being asked to take off clothing that she normally wears, to seek justice is really a bit perverse. What women say about their sexual assaults ought to outweigh what they wear on the stand. NS's niqab does not prevent an intensive and thorough cross-examination. That can still happen. And what remained unstated in this case was that the person who would most likely be detrimentally affected by the niqab was NS herself. In a social context, particularly in Canada, where, especially in India, the niqab is a little bit more common, you see it more regularly. In a social context like Canada, where niqab-wearing women are viewed either as fanatics who refuse to integrate, or they're infantilized as victims unable to see their own oppression, fact-finders like judges and juries, I think, are going to be less likely to trust their testimony. So I think the Supreme Court ought to have at least included some cautions about the documented problems with demeanor evidence. But worryingly, I think the case may renew focus on demeanor evidence as an indicator of credibility, reversing a lot of the reforms that have been made in response to sexual assaults that are more responsive generally to women's needs. Okay, let me turn to New Zealand. In 2005, in New Zealand, there was a case called Police and Razanju. There were two Muslim women who wore burqas, and they were called as prosecution witnesses for a criminal insurance fraud case. So these women were not in court of their own choosing. They were assisting the state in pursuing an alleged criminal. Defense counsel argued, just like the defense counsel in NS, that the inability to observe the demeanor of the witness would impair the accused's right to a fair trial. Judge Moore acknowledged that what was at stake in the case included the rights of the witnesses to manifest their religious belief, the accused's right to a fair trial, and the public's right to an open and public criminal justice system. So Judge Moore in New Zealand accepted the witnesses' sincere beliefs, indicating that the state must not make pronouncements as to the correctness of a person's faith, and found that to allow them to wear burqa while giving evidence to not allow them to wear their burqa while giving evidence would be a prima facie breach of their basic religious freedom. Judge Moore, however, noted that if a woman wearing a niqab was to expose herself to an entire courtroom of people, that could be very upsetting to these particular witnesses. Indeed, one of the witnesses in the case, when questioned in a voir dire, said that she would rather kill herself than reveal her face to an entire courtroom of men while giving evidence. So in Razanju, Judge Moore created a compromise between two stark alternatives of either taking off the veil or not testifying. What he did was he had the women testify behind a screen with their faces uncovered so that only the judge and the counsel, the two counsel, and the female court staff could see their faces. And this compromise was arrived at based on Judge Moore's questioning of the witnesses and their beliefs, including some exceptions that they noted to veiling. So one of the witnesses, Mrs. Salim, testified regarding some relaxation in relation to being unveiled in the presence of relatively aged male authority figures. In this case, the judge and the two lawyers were aged males, and she was okay with revealing her face to these particular men, but not to an entire courtroom of people. Okay, so he listened to these witnesses testify, and this is what he said. A sense of the witness's character emerged, though much more slowly than is usual. Courts and people adjust over time to the new or strange. So Judge Moore concluded that there could be a fair trial even if Mrs. Salim and other witnesses like her gave evidence wearing their burqas. So he said it's a little odd, and it's not what I'm used to, essentially, but I could get the evidence without too much difficulty. Despite saying that, that wearing a witness who wears a burqa would not compromise a fair trial, Judge Moore was concerned that if he allowed this, sort of these adopted procedures that were so out of keeping with the expectations of the community, that it would call into question the public's confidence in the justice system. So what he did, his compromise, was that he required the witnesses to testify behind a screen such that their faces were visible only to the male lawyers and the judge, but not to the entire courtroom. Well, in my view, this was not the most convincing reason to take the approach that he did, because I think it encourages the belief that certain religious practices that are outside of mainstream conventions have no place in public life. But interestingly, after Razumju, legislators responded in New Zealand and they enacted a statutory means of accommodation that permitted a witness to give evidence in an alternate way on the grounds of linguistic, cultural, or religious belief. Now, demeanor may be useful, or at least judges may feel that demeanor evidence is useful. Seeing less of a witness's face does not sufficiently impair the ability to assess credibility, or at least that's what I would argue. I have done some judicial education on this topic, and I would have to say that the judges I've met do cling very tightly to being able to see and hear the witness, which I suppose is understandable if that's what you're used to. But abridgments of the ideal demeanor package often occur in practice. And that could be because you had a stroke and half of your face doesn't move. It could be because you're using an interpreter and the witness is speaking in a particular language and the interpretation is happening not contemporaneously. You could have an exception to the hearsay rule. You could have a witness who may not be able to testify at all because they've died. And what's happening is you're submitting trial transcripts from previous hearings. These are all departures from the ideal of having demeanor evidence available. But they don't disqualify the evidence. All that they do is maybe affect the weight to be given to the evidence. But you don't say, we can't hear from anybody who's had a stroke or anybody who wears a beard. We don't say that. So there are circumstances when judges hear evidence without being able to see demeanor. For example, evidence may be taken over the telephone. We have judges in the world who are visually impaired, so they are not seeing the witness in the same way that able-bodied judges are. Judge Conway Casey from America is one example. Okay, so let me turn to an English criminal law case. Judge Murphy in England relied primarily on the concurrence in NS. So NS, remember, was the sexual assault case coming out of Toronto. The majority of the Supreme Court of Canada said, they created this test that said sometimes women who wear the niqab can wear the niqab. But the concurrence in NS was pretty clearly against the niqab. And Judge Murphy in this English criminal case relied more on the concurrence. So in the Queen and DR, this was a 2013, so fairly recent case, a woman was charged with one count of witness intimidation, which was alleged to have occurred while she, the defendant, was covered by a niqab. So in a pre-trial proceeding, Judge Murphy solicited submissions on the proper treatment of DR's refusal to remove her niqab in the presence of any man. Judge Murphy accepted the assertion that DR's religious belief was sincere. However, Judge Murphy preferred the characterization that the niqab necessarily hinders the full openness and communication demanded of an adversarial trial process. Amazingly, Judge Murphy described the impact on DR of having to remove her niqab as merely causing some degree of discomfort. So, there was no discussion of the typically heralded rights of the accused to a fair trial, to make full answer in defense, nor was there much emphasis put on the fact that DR was being brought to court out of compulsion, so she had no choice in the matter. For the devout, religious requirements are experienced as obligatory. So Judge Murphy was incorrect in his pronouncement that DR was, quote, free to make the choice of how to dress for court. Indeed, for DR, this meant being unable to give evidence in her own trial, which undoubtedly compromised her ability to provide a fulsome defense. So the decision forced DR to choose between wearing her niqab and participating in the defense of her liberty. So in effect, it was no meaningful choice at all. And how fascinating that in earlier cases where the complainant was the niqab-wearing woman or the witness was the niqab-wearing woman, then all the talk was about the fair trial rights of the accused. But where in DR the accused was the niqab-wearing woman, then we weren't talking about the fair trial rights of the accused at all. Judge Murphy's analysis also, I feel, seriously misapprehends how religious accommodation analysis functions. So he said, and I quote, "If D is entitled to keep her face covered, it becomes impossible for the court to refuse the same privilege to others, whether or not they hold the same or another religious belief, or none at all." End quote. So when an individual from a religious community seeks inclusion in society through an exemption from a rule of general application, this appeal to recognize how neutral laws disproportionately burden certain minorities cannot be assumed to be discriminatory. To provide a relief of accommodation is to recognize that treating everyone similarly does not always result in equality. So Judge Murphy's beleaguered accommodation analysis is a little troubling, and sadly it's identical to popular beliefs that equate accommodation with an inability to set any limits. It permits declarations of the kind that accommodation requests, multiculturalism, and indeed equality measures have gone too far. Niqab-wearing women appear to be in the paradoxical situation of being a niqabi complainant who too greatly impacts the fair trial rights of the accused, yet being a niqab-wearing accused, she also greatly impacts the rights of others for them to ever be permitted to wear the niqab. So there's no principal distinction between NS and DR. The only point of distinction is that a woman wearing a niqab is featured. So running parallel to judicial decisions prohibiting or severely limiting the niqab in courtroom settings are legislative attempts to enact regulations that prohibit or sanction women for wearing the niqab in public. I'm sure you know, France and Belgium have passed laws that prohibit face veiling in all public spaces. A French member of the Conseil d'État stated that Islam frightens, and this ban of the niqab is an expression of that fright. And the Grand Chamber of the European Court of Human Rights upheld the French ban in a case called SAS in France. The Netherlands came close to adopting a ban, with Dutch politician Geert Wilders proposing a head rag tax on women wearing headscarves as a levy for their pollution of public space. The United Kingdom, Italy, Switzerland, and Australia have all debated bans of face veils, with Turkey, Syria, Egypt, and China implementing some version of a ban of face veils. Canada has not been far behind, with 3 attempts at banning the niqab in different contexts, including voting, during citizenship ceremonies, and while working in the public service. So judicial prohibitions on the niqab legitimize the pervasive belief that wearing the niqab is a practice that provokes the rest of society, emboldening radical attempts at prohibiting the niqab more generally. And indeed, we've seen this in Canada. Harassment against Muslims has multiplied during several of the niqab controversies. Muslim women who wear the hijab or niqab have faced an increase in disturbing acts of anti-Muslim intolerance, from spitting to racist insults. And this was certainly at a high in our recent federal election when one political party really made this an election issue. Judicial and legislative ideas that exclude niqab-wearing women lower the bar in terms of what can appropriately and publicly be said about Muslims, and indeed what can be done to them. They influence Muslim women's everyday experiences of belonging, and certainly these exclusionary discourses coexist with more inclusionary assertions of support and powerful resistance from women themselves, from strong alliances of civil society. But these historical moments change us, and the implications for Muslim women are very real. The issue of niqabs in courtrooms will likely arise in other jurisdictions as well. It's already been addressed in New Zealand and Canada and the United Kingdom. The fact that DR cites NS and NS cites Razumju reveals the interconnectedness of Western jurisprudence, and that these decisions literally impact how law treats Muslim women across Western jurisdictions. The denial of entry in courtrooms to niqabi and hijabi women has also happened in 2 US cases, disclosing that the problem of disciplining dress and prohibiting certain religious expression is arguably rampant. The value in thinking about niqab-wearing women is that their legal treatment can also impact the way in which we consider justice for minority communities more generally. So we might ask, how can we structure legal institutions so as to equally distribute burdens attached to difference? How can we consider this minority whose needs were not built into the structure of mainstream institutions? And these sorts of questions can help us frame issues from the perspective of the minority. And I'd argue that it is only by considering the plight of the most marginalized that justice can be achieved. So I'll end my remarks there, but I'm very happy to answer any questions.
Let me, if I may, just use my thing quickly and just ask you actually a very sort of simple question. It's, you built your argument on the adversarial trial, or some bits of it are, in your engagement. Now, I know, like in France and so on and so forth, there's a political system which shuts things down, as at the very top, so that's over and done with. But would an inquisitorial system maybe sort of be more sensitive, to multiculturalism?
An inquisitorial system, by which you mean?
I mean, a non-adversarial system. Mm-hmm. The European sort of,
right.
Where you gather your evidence more differently, where
yeah.
the judge is much more in charge of collecting stuff. So I wonder if in those jurisdictions, you know, it may be interesting, it may be trivial actually, but, you know.
It's a good question. I haven't given that question much thought, and I don't know much about that system to be able to think about whether it would make a difference. I think one thing that it might make a difference when I sort of put some thought into it now. When you're working in a system, an adversarial system, the way in which you test evidence, or this is what a lawyer will tell you, is that the way in which you test evidence is through cross-examination. So a witness will go up and tell her story, and then she's cross-examined by the lawyer from the other side. And there's a real belief, really strong belief, and almost a religious belief, in the efficacy of that system of cross-examination. And again, I'm not convinced that the system of cross-examination is really getting out the truth, as much as it is really getting out that human beings can make inconsistent statements, that, you know, it's a way, any very good lawyer will tell you that they can trip anybody up. But that's not necessarily getting at the truth with respect to whether somebody committed a crime. It's creating reasonable doubt, but it's not really getting at the truth. But there is this fervent belief in cross-examination as a way of testing evidence, and I'm not so convinced by it. Just as I am not convinced that seeing a witness is really giving us the kind of evidence that we think is critical. And you know, you hear it all the time and from appellate courts that we have to give deference to lower courts because they've had the ability to see the witness, to hear the witness, you know, in a way that even though all of the evidence is in documentary form in front of them, they somehow still have to give deference to the fact that the trial judge was able to assess credibility, by which it means, you know, check out their demeanor evidence. So it's possible that an inquisitional system might work better because there's less faith in that sense of testing evidence in that way. Yeah.
And it's just stuff that
Yeah,
in the future you
think
can
about.
just like...
Absolutely.
Yeah. I have one question. It's like, what about the implications on those women who believe that wearing niqab is not necessary for them, but are forced by the community members to wear it? Like in this case, like say, like on one side, of course, it's about, you know, religious right, inclusion of the religious right. But on the other hand, there might be women, a section of women, who do not believe in wearing niqab and who say that, you know, it's not necessary for us or for me to believe this on this particular religious requirement.
Right.
And what will be the implication, say, if the judge has said, like in a affirmative, he has like say in a positive context, okay, this is right, we can allow this particular thing within the courtroom. But what would be the implication of this particular judgment on, say, those women, and about the, you know, community members forcing them to do this, taking into consideration the fact of the judgment?
So it sounds to me like your concern, maybe it's hypothetical concern, is that if a judge says it's fine, it's no big deal, and the niqab-wearing woman can come into court and testify, then that is somehow the fact that, you know, a judge has said this gives this particular perspective some credence, and the concern is it's going to put pressure on other communities of women who may then feel they need to wear the niqab. That's certainly the argument that happened in France around the headscarves. Is that your concern? Is that
the effect on the community members forcing the women of the same, like, you know, like those who wear niqab and those who believe that it's not necessary to wear the niqab, but the community members forcing them, taking that into consideration that a particular judge has given the decision in the favor that, you know, you can wear the niqab in the courtroom.
So I can only speak for the context that I know.
Yes.
But the context that I know, where there have been studies done, where they've actually interviewed niqab-wearing women in France and in Canada, there is no evidence that women are being forced to wear the niqab. That's not the evidence. They are saying, we are facing opposition from our family members, from our husbands, from our fathers, to take off the niqab. Because they're, you know, the men in their families are concerned they're going to be harassed on the streets, that there's going to be violence against them. So That's not the evidence in Canada and France. Not being forced. It could well happen that she's being forced to wear whatever article of clothing. But I don't think that denying women access to basic legal institutions like courtrooms, like public service, is the answer to that question. If people are being forced to do something they don't want to do, that may not be a legal question at all. I think that is better dealt with through education, through public services like women's shelters. Like, I just think that's the wrong approach to try and legislate because there's a concern that women are being forced to do something. So that would be my response.
Yes, please.
Yeah, I just wanted a bit more about your evidentiary, when you started you said there's this report in Canada which suggests that women are doing this on an individual basis rather than a community basis. So I'd like to know a little bit more about that study,
Sure.
because what the sample size is, what sort of, all those kind of questions. And then, have you come across in your study a kind of a comparative question about other forms of dress which are also not allowed in courts?
Right.
Right, so you can't give evidence naked, I would assume. But
It hasn't come up yet, but
well,
you know.
it could, because in
Sure.
the UK we've had a case where this man has been arrested and incarcerated multiple times for walking. He likes to walk naked. He's one of the nudist people.
Yeah.
And he's come up against the court, and in court he's been made to put on clothes.
Right. Interesting.
So I was just wondering whether there are other categories, and then if we are not thinking about those categories, why are we thinking more about the category of the niqab?
Sure. Okay. Great questions. So a little bit about the report. The report was, as I said, by the Canadian Council of Muslim Women, and so we don't know the numbers of niqab-wearing women in Canada. I doubt we know it in the United States either.
No, I just wanted the numbers in the report.
Yeah, I'll tell you that. So we don't know the numbers generally because it's not the kind of census information one gathers. So this was a report that was focused on Ontario alone, and they interviewed about 80 niqab-wearing women. So it's not an insignificant number, but at the same time it wasn't a quantitative study, it was really more a qualitative study. So anyway, it was about 80 women. That's all I can really tell you about the report. The report in France, I think, was probably a larger number of women who were interviewed, but I can't remember off the top of my head how many there were. And they found the same kind of thing. So the question about whether there have been other restrictions from other communities in terms of dress in the courtroom is an interesting one. In the United States, there used to be restrictions on people wearing hats in courtrooms. So a Jewish man wearing a yarmulke was considered a problem. Rastafarians who had long dreadlocks have been considered a problem. All of those cases ultimately resolved, and what judges have eventually realized is we live in a diverse society, and what is a sign of respect from one community of people is not the same for another community of people. And we make those kinds of accommodations all the time. So, in Canada, if you go to testify in court, you'll still be offered a Bible, even though we are supposedly a country that separates religion and the state. You will still be offered a Bible to swear, unless you specifically say you'd like to affirm, or unless you specifically said, I'd like a Quran, please, or I'd like an eagle feather, or so. And those accommodations judges are supposed to know about, but the truth is judges have the inherent jurisdiction of their courtroom, and if they are knowledgeable and sensitive, they will make those adjustments and those changes on a case-by-case basis, but they certainly don't have to. I'm trying to think. Sikhs in courtrooms carrying the kirpan has become an issue. That has, for the most part, resolved. You can enter a courtroom, I would say. You certainly can in, I would say, Ontario. I know of Sikh lawyers who have argued at the Supreme Court of Canada with the kirpan. It's not been an issue. But it continues to be a symbol that carries controversy in the same way that the niqab has. And so I also know that has been an issue in Quebec courtrooms, for example. So it really is, it's individualized still. There's no sort of overhauling, there's no legislation that sort of dictates anything like this. But, you know, we have the Charter of Rights and Freedoms, which protects religious freedom, and this is such a minor, it's a minor accommodation, so it should be something that's pretty pervasive. But just last September, a Muslim woman who wore a headscarf in Quebec went to court to try and get her car back, which had been, you know, mistakenly taken, and the judge said, I will not hear your case because you are not suitably dressed. And there was a huge hoopla that was created. This judge a complaint was launched to the National Judicial Council. They did nothing because judges have a lot of independence. But it's kind of crazy that in 2016, a judge is going to say you're not suitably dressed because you're wearing a hijab. So it's not sort of surprising that the niqab issue has come up. What makes the niqab different is carrying a kirpan, wearing a headscarf doesn't affect your face, and there is still this belief that there's a lot of information that one gains from looking at the face, even though all the social science literature tells us what you think you're getting from the face is you're probably mistaken, and that you can, you know, actually get more information from body language. I mean, you're probably not trained in how to access that information, even though you think you are. So.
Thank you very much for a very fascinating talk, people.
Thank you.
I have two questions. One, thinking of a case.
Just
in-
put it off and shout.
One, thinking of a case in India in the late 70s of this woman who was repeatedly asked to unveil herself when she was giving testimony in the context of gang rape. So each time she was asked to either to identify somebody or she was examined in front of a new witness, she was asked to unveil herself. And the experience of that has been described by people who've written about this case as an experience of stripping.
Sure.
Yeah, because the entire experience anyway is sort of organized in an extremely pornographic way. So I was wondering whether from the point of view of the rape survivor,
Sure.
that one would think of this as a mode of stripping. The other sort of question I had was in terms of courtrooms. There are some courthouses in India, like for example the Madras High Court, which has a prayer room for Muslims, or there are different kinds of, which is built into the court structure.
Right.
So in terms of, to phrase Shireen's question a little differently, in terms of the architecture of the court, in terms of language, so the demeanor question is extremely interesting because visuality is privileged in the courtroom in these so many different ways. But does it sort of also link up to other kinds of modalities, such as the architectural modality of the courtroom?
Also, can I just add to that in a way? It's like we've been talking about this. It's like also where there's the fact that, and maybe I'm completely wrong about this, but the fact that sometimes, at least in the UK courts, children are sort of, cross-examined
Yes.
behind a screen.
Yes, yes. Okay, great. Your question actually reminded me something of something that you had spoken of earlier. So absolutely, I mean, there was a woman, so I mentioned very briefly that in the US there were a couple of niqab cases. So there's one woman named Jinnah Muhammad who went into she had a small claims dispute, again related to a car. And the judge, she was wearing a niqab, and the judge said, so this is small claims court, which means it's like the lowest level court. It's like matters of $10,000 or less, minor stuff. And the judge said, I need you to take off your niqab so that I can assess your credibility. And she said in response to that, I will not take off my clothes. And I thought that was really poignant because the truth is, if I were asked to take off my blouse in order to testify in court, people would say, that's ridiculous. Why would she need to take off her blouse in order to testify in court? But that's how she saw. It's an article of clothing that she wears all the time. And to strip her of that I mean, it's really kind of perverse. There's a very famous, she's a complainant, a very famous sexual assault victim who sued the Toronto police and was successful for a variety of reasons. So she's become a very important sort of speaker, and she's known as Jane Doe. And what she said in response to the NS case was, the only way that people will believe women when they talk about their sexual assaults is if they strip completely naked. I mean, how else can you tell if they're lying? The only way you can tell is if you see them completely naked, and she's completely vulnerable. So obviously it was kind of a perverse way of looking at what the judicial system does to women. But yes, that's exactly the kind of thing that, I mean, sexual assault is not only one of the most underreported crimes, but it's also the crime that is the hardest to get a conviction. It's virtually impossible. And so, you know, when you add the layer of religious minority that's kind of hated, you know, certainly in this world of terrorism and anti-Muslim hysteria, it's, you know, if I was NS's lawyer, I would have said to her, seriously consider. I know that this is a, you know, really important garment for you, but seriously consider whether you want to wear it, because a judge maybe would be able to see beyond it. I highly doubt a jury of 12 peers would be able to. You know, I think it would really be a disadvantage to her. So yes, in Canada and the UK, I think in the parts of the United States, maybe not all of the states of the United States, you can have a child testify in courtrooms behind a screen. And typically they do that because they want to protect the child from having to be re-traumatized by the accuser who sits right there. And so they have the child testify in another room, and they have like a screen in which everybody in the courtroom can see the child, but the child can't see what's happening in the courtroom. And that was sort of suggested in NS, but it doesn't, the lawyers for the two accused weren't happy with that, and neither was NS, with that particular compromise, because NS wasn't concerned about, she didn't need to be in a different room from her accusers. She just didn't want to take her face veil off. And even if she was in a room, you know, 2 doors down, she still didn't want to take her face veil off so that it was going to be visible to a room potentially full of men. So that same sort of accommodation, it just didn't quite work. It might, so in Razem Ju, you know, when the Judge Moore asked Mrs. Salim, you know, would you be willing to take off your niqab in any sort of circumstance? And she said, you know, these are the exceptions. If I'm like talking to a male figure who's relatively aged and in a position of authority, I'm willing to do this, but not in a courtroom, a public courtroom. So, you know, that kind of compromise was possible because of Mrs. Salim's beliefs, but it wasn't possible because of NS's beliefs. She was like, no man, you know, I'm happy to identify myself to a courtroom official, make sure that, you know, the person that I say I am, but I'm not willing to take my face veil off in front of any man, I guess, who's not a relative of hers.
I see 3 things out of it relating to the clothing and the judicial place, that is the courtroom. So, one is personal idea of decency, the second is religious right, and the third is issue of gaze. So,
Issue of?
Gaze.
Gaze,
So, in relation to personal idea of decency, as there was a official Oscar movie which was sent for Oscars from India, court movie. There, in that movie, the judge says to a woman who was appearing that because you have wore a sleeveless top, I won't allow your matter to be heard, so you can come again next time. So that is one. The first case is personal idea of decency. So it might be, you know, according to the judge that is indecent in a courtroom, and that can vary very well. Okay, like for him it might be indecent, but for the lady it was very much decent, and can vary along for other people. The second is issue of gaze. So with respect to this, I've seen like many women who, like, you know, while driving their say motorcycles or 2-wheelers, they put on that particular thing, where you cover your only eyes can be seen.
Sure.
Okay, in India, I'm saying.
Yeah.
Okay, so that is, I think, because there was an article on it that was not to save yourself from the dust or the sunlight, but that was for saving yourself from the gaze thing, because like the staring thing.
It's not about pollution.
No, it was not like, because I read in that article that it was because the author of that particular article has talked to many of those women, and he has said that it's because of the gaze issue.
Sure.
Or the staring issue on the part of the male, and not because of the dust or sunlight.
Right.
And the third is religious right. So when you see, because most of the times we balance things. Whenever we speak of a particular right in law,
Sure.
we balance things.
Yeah.
So how do you, again, because of course we talk, you have argued with respect to the inclusion of, because this is a very small accommodation you have said, and
Yes.
because it can be very well allowed. So how do we balance the demeanor thing
Yeah.
and the requirement of the inclusion of this religious right? If say the court says that in the case, because we also balance, we need to consider the demeanor thing also, the facial expression of the witness or the accused or the defendant. So if the court says that say niqab cannot be allowed, but hijab can be allowed, like something which covers your entire face except your eyes, that cannot be allowed, but something which only opens up only your face but other things can cover up, that can be allowed. So what will be your argument on that?
Okay, so very personal. Sure, they're dictated by all sorts of different factors, religious leaders, community members, what's in scripture, but ultimately it's pretty personal. And the way in which religious freedom works in Canada, the United States, and certainly internationally, is courts are not going to get involved in internal debates about a religious community. So Muslims will say, the niqab is not a religious requirement. Nowhere in the Quran does it say you need to cover your face. All it talks about is modesty. And it talks about modesty for women and men. So you can have all kinds of arguments, but it's kind of a useless argument because ultimately what matters is the person's sincere religious belief. So that's the way religious freedom works I would say in sort of most bills of rights. You ask whether the claimant sincerely believes. Because, see, if the state gets involved and says, we are going to say that for Muslims, women must wear the hijab, it's highly problematic. I mean, it totally violates the separation of religion and state. A Canadian judge has no expertise whatsoever in Islam and Muslims, so there's no way that they could sort of say that without it being highly problematic. So I think then the question becomes, if we're accepting that it's about sincere religious belief, then we have if the niqab is not allowed, then it's a prima facie breach of religious freedom. Then the question is it worth breaching? So we value religious freedom. Is it worth breaching this individual's religious freedom because of the information that we can gather when we see her face? Well, I'm making the argument you're not missing out on a lot of information. You still have access to her eyes. You still have access to her voice. You still have access to her body language. And more importantly, you have access to her words, what she's telling you. So I'm making the argument you're not losing any information. And if you are, it's minuscule. Allow the evidence. Weigh it accordingly if you think you're losing information. Now, you also talked about other rights, and I think that's an important question. In NS, the argument, there were a lot of interveners. You know what interveners are? They are community organizations, legal organizations that have an interest in the case and the law that's going to be made by this case. So they come and they put arguments forward, even though they don't have a direct interest in the case. So there were a lot of interveners in NS, and some of them were mainstream women's organizations because they were concerned about the law of sexual assault. Feminists have made arguments for years about reforming sexual assault so that it is more comprehensive, more able to be sensitive to the needs of victims. I think that the NS case focused too much on her religious freedom and didn't talk about the women's equality angle of it. And that, I think, was a mistake, because I think, when you're balancing fair trial rights of the accused against just religious freedom, it's sort of not quite
what the case is about. It's actually about her religious freedom. It's about women's equality versus fair trial rights. And even fair trial rights I wouldn't put on just this side. I would say it's also about how our society is viewing prosecution of sexual assault generally. So anyway, it's just another way to think about how this case ought to be framed. And of course, I think the sexual assault case is the hardest kind of case when it comes to niqab-wearing women. But the case of DR in England, given that she was the accused, you know, her fair trial rights were at stake. She should have really been allowed to wear her niqab, because if it's going to affect anybody, it's going to affect her. But somehow the judge, even in that case, said it's about the rights of others, the rights of witnesses, the rights of the public. And even in that situation where she was the accused, and I think ultimately pled guilty, you know, it wasn't about the rights of the accused at all.
Well, thank you so much.
You're very welcome. It was fun.
Right, and I think we have some tea outside. I have no way. Is there some tea? So Pratiksha showed me that there is. And if it isn't there, it will appear in another couple of minutes.
Okay.
So please join us for some.
Thank you so much.